I'm Vinny Politan. This is Closing Arguments, another jam-packed hour, big night, big cases, and we begin with the biggest one of all, the murder of 4 University of Idaho students. Xana Kernodle, 20 years old. Ethan Chapin, 20 years old. Kaylee Gonzalez, 22, and Madison Mogan, 21 years old. These 4 names, these 4 lives will be forever mingled together, connected, and never forgotten out at the University of Idaho. But there is a trial that needs to take place, and the accused killer who's been charged wants the indictment thrown out. And there's a big hearing tomorrow, and Court TV legal correspondent Chanley Painter joins us outside that courthouse in Moscow, Idaho, tonight, where already it's getting cold. I can see, Chanley. Let's start here with the evidence. What is the evidence in this case against this accused killer who wants the indictment tossed?
Well, the prosecutors have so much evidence that they chose to seek the death penalty here and charged him with the top count, which, as you know, Vinny, if he is convicted and sentenced to death, that could possibly even mean death by a firing squad if the lethal injection drug is unavailable. So a perfect time to refresh our viewers on what that evidence is from the prosecution side ahead of this hearing tomorrow. Let's take a look at it. First, we know, of course, the biggest piece of evidence is the DNA that was found on the button of the knife sheath found under Maddie Mogan's body at the crime scene. That was first led to Kohberger's father, and then after his arrest, a direct match to his DNA. Also, an eyewitness there at that crime scene, one of the surviving roommates, identified a tall male with athletic build and bushy eyebrows leaving that crime scene. Well, we know Kohberger is 6 feet tall, 185 pounds, has those bushy eyebrows, as we've been showing our viewers. Also, most importantly, the video of his vehicle, the white Hyundai Elantra, traveling around the crime scene at the time of the murders. Vinny, that 2013 white Hyundai Elantra we've seen on video, and his cell phone data that aligns with that suspected route. We showed you night after night retracing those steps from that affidavit. And as of today, though, because he did waive his right to a speedy trial, the October trial date, of course, was vacated. We don't have a trial date yet for his death penalty case.
But we do have 2 hearings tomorrow. Can you give us some of the details of those 2 hearings?
Absolutely. Well, there's the first hearing. It's a closed hearing, so we won't be able to be in there and be privy to the details because it involves the workings of a secret grand jury proceeding. So that closed hearing is 9:30 local time, 12:30 Eastern, and it's taking up a motion from the defense to dismiss the indictment based on several grounds, including biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct in withholding exculpatory evidence. I wish we could hear more about it, but those substantive filings were filed under seal, so we won't know that, but we will be inside. Our cameras will be inside the courthouse or courtroom later that afternoon for a second hearing that will deal with kind of the same issue, dismissing that indictment, this time on the grounds of error in the grand jury instructions. And so they wanted either dismissed or in the alternate for the judge to remand to a preliminary hearing, Vinny. So that's what we will be watching tomorrow afternoon.
So the second hearing is the one that'll be open to the public, and that one is really based on some legal issues rather than getting into factual issues.
Right. It's actually a pretty interesting and complicated legal argument in the 23-page defense motion that was filed back in July. Here's part of what they contend that why this judge should dismiss the indictment. It says this motion is made on the grounds that the grand jury was misled as to the standard of proof required for an indictment. It cites statutory interpretation supporting get this, beyond a reasonable doubt standard for a grand jury to issue an indictment. They point to legislative history to support beyond a reasonable doubt, and that the failure to instruct that grand jury to that, Vinny, they believe is grounds to dismiss this indictment or, again, remand for a preliminary hearing. Now, the prosecution, as you can imagine, fired back in its response motion, saying that beyond a reasonable doubt standard is nonsense and unorthodox and in conflict with precedent here in the state. Here's part of what their motion says. It says that the whole of modern jurisprudence on this issue is against that standard. In the defense's jarring arguments, and the court would be duty bound to apply the controlling precedent and, of course, reject this argument. It should be, of course, in the prosecution's estimation, a probable cause standard, as would be the standard of a preliminary hearing, and not beyond a reasonable doubt. So that's what we will be listening to when that hearing is underway tomorrow afternoon.
Yeah, if Vegas was taking money on that one, I would put a lot down on the prosecution to win that one. But we'll see. You never know. We'll see. It's up to Judge. Okay, so you're out there, back out in Moscow. You've been out there so many times. What's the mood now as things are starting to move now in this criminal case?
Well, Vinny, we're only a couple of weeks away from the 1-year anniversary of the massacre that happened in this community. There are still signs of memorials here and there, but it is much a community that looks to be moving on. But I did catch up with residents and students who are back to school this semester, and this case is still very much on their minds. Let's take a listen.
Yeah, most people try to not bring it up because it's a sad subject to bring up upon, but everybody knows what happened and everybody mourns and everybody's upset about what happened.
We never go to the bathroom alone, never leave anywhere alone. A lot of the times we have boys in the dorms that'll come pick us up from wherever we are and walk us home.
Well, once they've pretty much found the person that could be the suspect, everybody kind of calmed down and went back to their old ways and with a little more vigilance or caution.
No, I hope he gets put in jail or prison for a while, yeah. And most people here do, nobody likes him.
It impacted a lot of people on campus. I told my mom 1,000 times, if I went here last year, I probably wouldn't have come back because the thought of that scares me.
That didn't know that his mind wasn't right and that he needed the mental health help to not have an incident like this tragic incident. It shocks you and you change your habits and you go from not locking your doors to locking them at night and figuring out where the keys to your house are so you can lock them during the day and get back in and make sure that there's nobody hiding in your house.
Sure. And Vinny, I learned today that there is an effort, a student-led effort to plan an event that will mark the November 13th date this year, just a couple of weeks away.
And let's talk about the crime scene, the house. You have some new details for us tonight about what's happening there?
I do. As you know, I always go and visit the crime scene. This is what it looks like today, Vinny. It's a beautiful fall campus, but still you see this is a mark. This is a place that students walk by multiple times a day to and from class. And in July, the university told Court TV that they plan to demolish the home in October. I checked back in. They say they are not going to demolish it in this semester. There's no time, but it won't be done this fall semester. And as you can imagine, Vinny, this is still a topic of controversy. Let's take a listen. On campus, you still see the crime scene, I'm sure. Is that something that you feel a sense that people want to be torn down or keep it there?
They're probably gonna keep it there just to let everyone know that it did happen, but also to just, you can't really forget something that big and traumatic.
The campus wants to tear down the home, so it's not such a constant reminder. Do you agree with that?
I think they should.
Yeah.
I think move past it and remember them always.
And of course, we know that the victims' families want that crime scene to remain through this trial, whenever it may be, Vinny. I did learn from the Gonsalves family they won't be here tomorrow in person for the hearing I just told you about. They will be Zooming in. That's something that this court provides every step of the way for not just the victim's family, but the defendant's family, if they want to have a private link on a Zoom where they can watch it unfold without being here in person.
All right, Chanley Painter in Moscow tonight, big day tomorrow. Thanks so much, Chanley.
Yeah.
All right, let's bring in our think tank. Joining us live in the studio tonight, criminal defense attorney, entertainment attorney, former assistant DA in Fulton County, Georgia, Darrell Cohen. Also with us, criminal defense attorney, Emory University law professor, Georgia Innocence Project board member, Molly Palmer. And finally, the man behind the glasses, criminal defense attorney Josh Schiffer. All right, first things first, the woman with the raincoat, not allowed to be on this jury, referring to the mass murder as this incident. And then the one student who said, yeah, hopefully he'll go away for a little bit of time. Keep them off the jury, please. Okay. Can we agree that this beyond a reasonable doubt for the grand jury is ridiculous, absurd, and a loser of an argument?
Well, we start with a crime that's horrible, horrific, and whatever other word you can think of. But I think Judge is going to judge the motion to have no merit. It's gone.
Gone.
No, we're not going to.
Molly wants beyond a reasonable doubt.
No, what I want is excellence in litigation. And when you do that, you often turn to these so-called canons of construction. These are tools that very sophisticated litigators use to change laws. You can bring up things like legislative history, legislative intent, and take an issue like this all the way to the Idaho Supreme Court and have things change. It happens.
And the only time litigators get an opportunity to do this is in a case just like this.
Yep.
You've got a death penalty case. Your obligation as a death penalty defense attorney is to go into every far-reaching, run down every single lead. If there's something in the legislative history that supports this, it's at least worth pursuing. Do I happen to think it's going to prevail? No, but it is the development of this discussion to make sure that our process works perfectly.
Well, let's talk about the process. The process is some secret court happening tomorrow again. These sealed motions dealing with prosecutorial misconduct. If there's misconduct or alleged misconduct, I think it should be out in the open.
I want to hear it. I want to know what the prosecutors allegedly have done to show that they have done prosecutorial misconduct. I want to see it out front, and it should not be hidden, because the very thing Josh and Molly are referring to is if it's out front, open and notorious, we know what, if anything, and likely nothing.
Well, I mean, in general, I wish grand jury was not a secret proceeding. You know, that's something that, as a defense lawyer, all the time I'm litigating. Can you turn over grand jury testimony? And I'm told no a lot of the time, because prosecutors are by themselves in a room and it's completely sealed. So no, tomorrow, the reason we're not going to hear it is because it's a grand jury issue.
And one of the weird contradictions in my life, this is one of those places where I support some secrecy because of the nature of the allegations being made weaponizes allegations against the state of prosecutorial mistreatment of the process, let's just say violations of discovery obligations, things like that. That's something that does deserve some secrecy, otherwise you're poisoning your potential jurors.
Okay, DNA, video of his car, cell phone data. Like, where are they going with this case? I don't see any way of getting out from under it. You know, sometimes you have one piece, maybe you have a surveillance video that's a little grainy and maybe you can make it. No, they've got his car. They've got his DNA on the snap of that knife sheath, which is beneath the victim. You've got cell phone data that has him up and about and then turning off his phone conveniently during the times of the murder. So where are they going with any of this?
Where are they going? The answer is nowhere. If his lawyer has a modicum of power, you switch to and say, please let my client enter a plea of guilty to life without parole. Otherwise, he is facing, as pointed out.
Well, do you think those negotiations are happening?
I don't know, because Mr. Kohberger was off to get some Thai food after he murdered 4 people.
Well, let's also be clear about exactly what the defense is arguing tomorrow. Everything that you just referenced, all of these pieces of supposed evidence that we've taken from the affidavit.
DNA is pretty good.
Well, wait. Let's talk about it.
Yeah, quick time out. Isn't that what the Innocence Project uses to get people released from prison? DNA.
And let me say something that has bothered me about the DNA in this case from day one. A crime scene like this, you know what we expect? Tons of DNA. We wouldn't just point to one button on a knife sheath, okay? So that's one issue.
Because he snapped it before he put his gloves on.
There should be DNA everywhere. Now, here's the issue.
He snapped it before he put his gloves on. He was dressed head to toe in black. All you saw were his bushy eyebrows.
What DNA now does now apply.
No, but what you're missing is you can take these individual facts and tell multiple stories. That's what Molly's talking about. These are all facts that you're taking at face value the way the state wants you to hear them.
Okay.
There are additional facts. There are different contexts that can be taken. There is a defense.
Yes.
There is
yes,
no defense. It's
yes.
once upon a time.